if I had to be another person to stand up, if I think after really going through this, and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
You're expected to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Good Wednesday evening. Welcome back into Let's Talk Live here on the LTL Media Channel. And I just feel like you can't look left. You can't look right anymore. And there's just something new in the Karen Reed case. It feels like every 5 minutes. There's so much information that has been dropping over the last couple of days. I'll be honest. It's even hard sometimes to even get caught up or absorb everything. And I'm going to bring in 2 amazing guests tonight to help kind of sort through some of this stuff, maybe strategize a little bit and talk about, you know, we're less than a week away here, starting with jury selection and the trial starting. So it's been wild, 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 wild west. And things have really been heating up over these last 3 hearings. You're getting spicy from the defense. You're getting spicy from the Commonwealth. And I think it's going to be a battle in the courtroom this time around. But let's do this. Let's bring in my guests this evening and talk a little Karen Reed tonight. So I'm going to bring in my longtime friend here on the channel. We'll bring in retired Mass State Police Todd McGhee. How are you this evening, sir?
Good to see you, Brian. Doing good, thanks.
Yeah, awesome. And the one and only, the famous, the YouTube famous and world famous Mark Bederow. How are you, Mark?
I'm trying to do this for my kids to hear. Nice to see you, Todd. Great to see you as always.
Good to see you, Mark. You can't get a better intro than that.
I need to get my kids to watch this later. Yeah.
So, all right. So tonight is Celtics talk. I know the Celtics are at the Suns, and it looks like Tatum's not going to. No, I'm just kidding. I'm kidding. Here we are. And today we have this juror that was a lawyer that's now going to join the Reed team. Mark, what's going on here?
I truly don't know. It's something that I've never seen, and I imagine no one has ever seen. It's about as shocking gets. It's a Massachusetts lawyer, so there will not be those hurdles that some other people had to go through and experience. So that's not an issue. And as far as I can tell, there's, as kind of bizarre as it sounds, I don't think there is any legal basis to stop it, even though your brain is kind of wired to say, how does a juror end up on the trial team a week before trial? So once you get past that kind of weirdness, I don't think there's any legal impediment to it. So the question then becomes, for what purpose? I imagine probably to be kind of, under the privilege umbrella, to be pumped for information about what the first jury went through, what you think worked, what didn't work. Obviously, this is an intelligent lawyer, so this is somebody who really, is going to be perceptive. From what I was told, I think she's, as far as being a lawyer, relatively inexperienced in terms of, maybe 4 or 5 years. Not a criminal lawyer, so I would be stunned beyond belief if she had a courtroom presence in terms of actually examining witnesses or doing anything like that. So short of that, the only two things that I think make sense are certainly a resource as almost like a jury consultant. Yeah. And I suppose potentially as a hedge, some of these lawyers are still on the witness list, as ridiculous as that is, even after yesterday's smackdown on trying to get the privileged communications of David and Karen. I suppose having another Massachusetts lawyer could act as a hedge if something were to happen to David, which is not going to happen, by the way. Yeah. But so I imagine that's what it's for, but it's no one's ever seen anything like this.
So wild.
Yeah, Mark, I agree with you. I see the angle of, maybe some type of jury, consultant or over, someone oversee, during the selection process, and, just having that extra experience, from trial 1.0. But, to have someone stand in for Yannetti or Jackson, don't see it at all.
No, this is a high profile murder case. It's pretty much the biggest, case in the country or close to it. Maybe the one in Idaho is up there. Who knows? But, this is a pretty big deal. And I don't think anybody would expect someone at that experience level and behind, that far behind the 8 ball in terms of familiarity with the case, even though she experienced the whole first case, to just jump in and say, you're going to try a criminal case of this magnitude. That can't possibly be the role.
Yeah, and we saw Vanity Fair put an article up about it today that caught the local news around here too. So I was just like, this is wild. I know Aiden was tweeting, like Aiden had it right away. I was just like, what is going on here? I couldn't make sense of it. And then just started thinking about, like, well, they sat in that jury room. They got the vibe for what was going on in that room. Great consultant, I guess,
Yeah, no, it is interesting. I did see the Vanity Fair piece, I guess, like 30 minutes, an hour ago. I guess on some level, I'm happy to have been the impetus for this. My misfortune apparently was an impetus to make this happen. So I'm happy to have helped in some way, since the judge won't let me help in the way that I should have helped. But, we'll just have to wait and see. There'll be a role. And I don't think it's going to change the dynamic of the trial at all. It's just very interesting. But there are other lawyers, too, that, again, have notices of appearances to do this. And, it does make for an interesting story. I don't think it will impact the trial itself too much, though.
Yeah, I want to get to this really quick, and I know someone just asked. So Robin's asking you, Mark, how aggravated are you that you aren't part of this historic moment?
Pretty aggravated. Let's be honest. This is something that I's were dotted, T's were crossed, and I had to listen to a prosecutor essentially misrepresent a series of facts, make all kinds of allegations that are entirely not true, in the form of a non-objection objection, and have a judge then, without having the opportunity to be heard, rule that I had a conflict, which was not an unwaivable possible conflict. But at the end of the day, it is what it is. If you've been doing this a long time, you recognize that judges make rules, lawyers follow them, whether you like it or not. And the reality is, it's not meant to be. So other people will do it. They're going to do it fine. Every expectation, she's probably going to get acquitted. Nothing changes with that. But there'll be other people doing it. That's all.
Yeah, and I assume that both of you watched the juror interview with Aiden. And a thing that I just couldn't get past is, and we were just kind of talking about this in the green room, is that we had a good juror come forward, and he said the basic thing that we outlined here was, two people left the bar, they assumed to be drinking, one got out, one got hit, one left, and then all that other stuff in between was static. And I was like what? How can you ignore all of that? So maybe hiring on this juror, this attorney, gives them a little bit of insight again, as to how everybody was thinking that in that room.
Right.
Go ahead, Todd.
Thanks, Mark. Thinking about just the way the police investigation went down initially, not even talking about MSP involvement, but the initial, the blunders with Canton PD that kicked this whole thing off, to have no mention of even that was kind of disconcerting.
That's wild. It's bizarre.
The other thing too is, the juror that you're referring to who gave the interview, from the defense standpoint, that was a good juror. That was an acquitting juror who was giving you this analysis that, as you noted, Brian, it's a little disturbing. I don't know what that translates to by saying, well, does another juror agree or disagree? The reality is, because by all accounts, the new counsel of record, former juror, was also, although she didn't deliberate, the news articles or whatever we've seen online suggest that she was another acquitting juror. To be candid, there's much more to learn from a juror who disagrees with you than one who agrees. Now, whatever, that's neither here nor there in the current situation, but I think as a lawyer trying a case for the second time, I would be more interested in a perfect world of hearing from a juror who didn't see it my way than perhaps one who did.
Yeah, makes a lot of sense. You can gauge a lot of information, like what kind of swung them that way.
Right.
What was the initial thoughts? What evidence, that you did that didn't stand out to you, or what did? Yeah, it's a really great point.
Certainly help the strategy out. Sure.
Yeah, absolutely. It helps with strategy. We can just shift a little bit, gears a little bit. And I kind of want to go back to a couple weeks ago. And I'd love to hear both of your comments about this, as I know Todd was on the show last week, and maybe some people in the room here didn't hear it. But thoughts on Proctor, the firing, the timing of it. Were you surprised, Mark? And just all the basics, how this is going to affect the case, good, bad, for the Commonwealth or defense, and do we see him testifying? I know that's a loaded question, but I'd love to hear both of your opinions on that.
Well, I guess we'll defer to the state police expert first, because I'm fascinated about the timing and what you think, having, you've been under the kimono in there, so it'd be interesting to hear, I think, what Todd has to say first and foremost.
Yeah, so, as far as the decision by Colonel Noble, you had at the time a sworn member of the department testify under oath as to their misconduct. I don't know what appeal or, every department member is obviously has, due process with the hearing, the process of the hearings before the trial board. But how do you back away from, testifying to your own misconduct under oath? I just, so you start the process. You have your internal affairs. They're on a fact-finding mission. They don't make any decisions, but they present that information. That information goes before the trial board that's assembled. They have their hearings. In this case, we had 3 hearings spread out over several months. And, their recommendation then goes to the colonel. Keep in mind that even without the whole debacle with the misconduct, there's several problems, that the state police has come across with different scandals. First time in history that a colonel superintendent was hired outside of the department. So, that tells you a message. And again, take the Karen Reed trial off the table. Colonel Noble was brought in for specific reasons. So to think that a high profile case like this that has the chance to impact other high profile cases, i.e. Brian Walsh case, and others, I just not surprised at the outcome.
Todd, let me ask you really quick. Obviously, these hearings got stretched over several weeks or, a couple of months. Do you feel like they were kind of kicking the can down the road and going, what are we going to do here? We know that this, this next trial is coming up. And I just found the timing interesting when, his wife and his family came out and did that interview, and it was like immediately the next day he's fired. He's gone. It was like, that was kind of the candle burned out right there. And they just said, all right. And then they made this motion that he's been fired. Do you feel like I said, do you think they kind of kicked this down the road a little bit and was trying to figure out, like, what are we going to do here?
Great question, Brian. I think the can kicking started back during trial 1.0. And in order to bring him forward as a witness for the prosecution, it was a rip the Band-Aid moment. They had to get him out there, good, bad, or indifferent, take the hits and move forward. And then what do we see? It's kind of a seeing patterns of behavior. Right when the trial ended, disciplinary action, right? So again, you had most likely influence from the DA's office. I'm speculating. I don't know that. But there was a reason for a delay in his appearance. There was a reason for a delay in any disciplinary charges. And, that's a significant time from June until they started his hearings. That's a significant time to be suspended without pay. And so, now you fast forward, and then when you see, the wife and the sister come out, you knew right then you're going to hear a termination decision within a short order of time.
Yeah. So what ultimately happens with him? Because a lot of people have been asking the question, like, can he be ever hired as a trooper or a police or a police officer? What he's done, right? He's never going to be hired as a law enforcement official ever again, correct?
Correct. And here's why. What's different now than when I was active within law enforcement is the MPTC is now the licensing authority, right? So at one time, once you took your oath of office upon academy graduation, you're a police officer. And if you moved on to other departments, if you had some baggage, typically you would leave the baggage behind and get hired and wear a new uniform. And what the standards and training has done, it's eliminated that. So that licensure or lack thereof will follow that individual around the country. I don't see him working as a police officer, municipal sheriff, corrections. Everyone's now licensed, at least in Massachusetts. Not every state has it, but that licensure will, or lack thereof, will follow him.
You see him going into some type of starting like a consulting firm or something like that?
What would be interesting, I'm wondering if the laws of being a private investigator, I don't know if the post licenses the private detectives or private investigators. If not, that might be an angle that stay close to public safety.
Yeah. Mark, your initial thoughts when you heard about the firing?
Well, this could be a long response, so bear with me. Where do you begin with this guy? First of all, I would have thought they would have kicked the can down the road past, the trial, not just because it looks better, but there's consequence. He's terminated. There are findings. There are specifications, including one of which was being biased, which is the death penalty to a police officer's credibility in any trial. That is as bad as it gets, particularly in the context of this case, where the defense is that the cops involved are scumbags and framed me and all of that. And now the the state police have concluded that he exhibited conduct that would suggest he may very well have been biased. That changed dramatically when, in terms of the timing, when you had that like really sloppy press rollout by the sister and the wife. Once they came out and gave their speech, I agree with Todd, that meant because they knew it was over. But if the goal of the exercise was actually salvaging Proctor's credibility, his decency, his manhood, then he would have spoke himself, and he didn't. So the guy has no remorse or anything. When he sends out these women to defend him, you have to also remember that these are the two women who wished that Karen Read would kill herself, and who were going to receive potentially a bribe for his arresting. I mean, so that's a disaster in and of itself. As far as what does it mean going forward, he's the albatross. I mean, the DA is damned if they do and damned if they don't. If they call him, you have to remember that as bad as you thought Michael Proctor's testimony was, say, 6 weeks ago, from everything that happened in the first trial, well, now there's been two major things that have happened to make it worse. Number one, well, three really. Number one, he's been fired. Number two, he's been fired for exhibiting bias against the defendant in this case.
Yeah.
Not a different defendant, literally the defendant on trial, which is terrible. And number three, he has become the useful idiot / patsy of Brennan and Lally for the Sallyport video fiasco. Whether he wants to be the patsy or not, they have unloaded on him, and I guess to a lesser extent, the Canton sergeant who is conveniently retired as well. So how convenient, the disgraced former trooper and the retired sergeant. So if they call him, he's going to get clobbered like nobody. If they don't call him, then what I would expect, whichever attorney is going to cross-examine him or cross-examine other people, particularly Buchanan, is going to use the name Proctor every third word, and that every single thing you did was with your lead investigator Proctor, and when you did this, he was with you, and when he recovered it, you were with him, and just wrap it around his neck, and then he's not there. So then the question becomes, does the defense call him or not? And that's kind of a trickier question. The answer is not so obvious to that, because if they do call him, they may have to direct examine him rather than cross-examine him.
Interesting.
Could he be deemed hostile? Maybe, but you can't assume out of the gate that he would. And it's much harder to direct and cross somebody who is clearly not trying to help you. And for example, all those text messages and whatnot becomes much harder to get in on direct and cross. So would they, or would they simply leave him out of it? His name is mentioned everywhere, and then when it comes time for summation, say, well, wouldn't you know it? How can you try a case like this? Now, does that smoke the DA out of the cave where they feel like they have to call him? I don't know. I mean, they unloaded on him in their rather pathetic response in their motion to dismiss. I mean, they just completely, swept his knees and left him holding the bag. So, because if he does testify, he's going to get asked about why he had video in his pocket for 2 years and felt compelled to tell nobody, if that's what he's going to say. I mean, who knows? He may say, well, you know what? Actually, I did tell. So it's kind of an open question whether either side will call him, but either way, his name will be mentioned by the defense as often as it can be.
Yeah, I heard
this is an unmitigated disaster for the DA. That's why he's an albatross. They can't win with this on this issue.
Yeah. And if you go back to your point, Mark, looking at Sergeant Buchanan's testimony, he puts Proctor out there early and often.
Yep.
Not my role. Yeah, I'm the supervisor, but he was the lead case agent. It's this was his area of responsibility. This was his area of control. So it's very, a lot of the
You're right. And that's very crafty and artful testimony too. I agree. I mean, I do recall that he was, I mean, he was very precise in his language and would battle back on words and whatnot. You know, certainly a much smarter guy than Proctor, clearly. But he did try to divorce himself at any opportunity to say that it was Proctor, and that could come back and bite them in the ass, because if there is something that Buchanan can't give them that's important and they're not calling Proctor, then where's it coming from?
Right.
Yeah. I was going to say, Todd, you know, things like this, when this happens, obviously there's conversations that are going around in the department. I know that you've probably never, I mean, all of us sitting here, we've never come across anything like this, but when there's disciplinary hearings and potential ability of one of the guys getting fired, are there conversations going around, or people pretty much keep quite tight-lipped through the department about that?
Oh no, there's as much conversation that you might want to speculate happens. But, you know, I did a couple of media interviews the day of the announcement, and one reporter had asked me, you know, will this impact morale? No. This isn't going to impact morale. Mm-hmm. He's a grown man. He's, you know, a lead investigator in an elite unit. And what comes with that is a sense of responsibility and ownership and professionalism. And, you know, hundreds, if not that, you get an agency of over 2,000 state police personnel in it that would never see themselves in this type of situation because they are professional. And so this impacting morale, I just don't see it.
I'm laughing when you say, you know, would the cops be talking about this? In my experience, having worked with and many police officers over the years, there's probably no profession, Todd, maybe you'll agree with this, there's no profession that has more chatting Cathys than police officers. So there's no way that this would not be going around the precincts, station houses, barracks, I guess, as it were, as in the state police. I mean, that impossible that it wouldn't.
You nailed it, Mark. You nailed it.
I even heard some strategy in this is that, let's just say the Commonwealth doesn't call Proctor, like you were saying, Mark, because it's such an albatross in this case. And then the defense doesn't decide to call him. But in their closing argument or closing statement, they turn around and say, look, and the Commonwealth wouldn't even call the lead investigator in this case because X, Y, and Z. I've heard that strategy kind of being thrown around. And I was like, oh, that's not bad.
No, it is, but it's potentially even worse, because what the defense would do during the charge conference is ask for what's called a missing witness charge, which when, one side does not call a witness who obviously would be expected to favor that side, it's clear the expectation is that they would have testimony that would favor that side. They're within that party's, possession, custody, or control, meaning, they know how to call him. Now, maybe the DA would argue, since he's been terminated, he's no longer their responsibility, which is a fair argument, I suppose. But either way, if he doesn't testify, I mean, they're going to get clobbered on that. And there are many, and don't forget, you're talking about in a case where the defense is the cops are corrupt. So, and then the DA doesn't even have the balls to call him. That's not a good look. That's not trying a case from a position of strength.
I know this might be a stupid question, and I know I'm probably out on Mars where I'm saying, you think they're throwing the case by doing this? No. Throwing Proctor to the wolves? And
well, I think they're clearly making him the useful idiot. I mean, what they did in their motion response a few weeks ago is very telling. I mean, that was not even a legal argument. I mean, they're responsible for the police when it comes to disclosure of evidence. And they didn't even make an argument about, anything about the disclosure of evidence. Their response was, we, meaning quite literally, the prosecutors personally didn't know. It's all Proctor's fault. I mean, they're clearly blaming him, because if he's already 100% discredited, what's the difference if he's 110% discredited? He's just useless to everyone, which is also why he'll never be a police officer again, whether he was eligible or not. He's as damaged goods gets. I mean, look at him.
What do you put in for references? You're going for that other public safety job. You just shot yourself in the foot.
How about the Google search of him? I mean, forget it, right?
Yeah, exactly. I want to give you two perspectives on investigation. Early in my career, I was doing accident reconstruction, responding to fatal accidents. We were not issued cameras, and that it's going to make sense in my second scenario, but we did field notes. So you would have a blank pad of paper. You would, indicate where the vehicle is, the roadway, any impact areas, how many vehicles, final rest of the body, final rest of the vehicle, and that would be considered your field notes. So you would do the best that you could do to recreate the scene. And then you would have eyewitness statements, and you would bring that forward. On occasion, that evidence that would be entered into evidence. I remember testifying before a grand jury to see if charges were going to be brought against an operator. So all that stuff comes back into play. Fast forward to my time in the fire marshal's office. We were trained as crime scene investigators for collection of evidence. So we were issued cameras. We were issued cameras, and so the protocol was photo, leave a marker where something of evidentiary value was found, and then bag it, then tag it, and then to the crime lab, where, again, you started your chain of custody. There are so many holes in both sides, Canton as well as MSP, where that didn't happen. Fast forward to Karen Reed's vehicle in Dighton at the parents' house. All we have is that Dighton officer's testimony, which I felt was extremely credible.
Yep.
Why wasn't that vehicle photographed on all sides? And even if it wasn't the DA's office, you have something called crime scene services, who are the experts for evidence collection. You call them out before the vehicle even gets on the tow truck, and you're documenting the vehicle's condition before it moves any other foot in any direction. That also didn't happen. So when they talk about the integrity of the actual investigation, even in those just missteps, it's compromised.
Yeah, it's wild, and it's funny that you say that, because there are so many holes, and that's just one of them. And the biggest thing for me I look at is literally the smoking gun is that. Right, and I was just there a couple of days ago. I took my friend. We went up to 34 Fairview. I took a friend of mine, my friend Lauren. She had never been there, so I took her there. We
call that the camping ghoul tour. It's awful, but people do it.
Yeah, it's awful. But she wanted to go up there and see it. And I think the biggest thing that I wanted to show her was right across the street at Deputy Chief Kelleher's house. There is a ring camera that is above that door. I wanted her to see that. And I said, you can't believe that there it is right there, that camera, it just didn't work that night and didn't capture everything. And this is my whole thing, is that in trial one, if Karen Reed did this, why not produce the video in your opening statement and show it and go, there you go. I mean, that would have just summarized the case and it would have been over. And that just leads me to believe is the reason they don't want to do that. And this is just my opinion. I'll state my opinion here, is because it showed a lot more that was going on that night. And it possibly showed, John being dragged out on the street and left in that yard. Why not produce that video? And then all the other holes, the library video, the Sallyport video that's been mishmashed and back and forth. And you don't even know if you're going to get a true copy of that video now. So it's insane. It's just insane. So let's just do this. We'll pause here for a second. I do want to answer some questions here, and then we'll move on a little bit here. So let's see. Pensive Peggy, thank you for the 10. Says, question: with having so many motions outstanding, how as a defense lawyer do you prepare your opening statement in general defense in so little time?
Well, they've been preparing for months, and they have 4 or 5 now. Lawyers, and you divide and conquer, and I mean it's it's the same as both sides, frankly. I mean, that there's no advantage or disadvantage. These are experienced lawyers. It's part of what trial practice is. I mean, this is a little crazier than most, obviously, with the amount of motions that go back and forth, but you do it. I mean, you budget your time and you do it. You don't wait to the last minute. They've been in full trial mode preparation for months. And as you slowly and steadily do it, you're able to do it. And, a lot of lawyers would have an opening statement prepared already. Some may not. I don't know what's going on, what they're doing right now, but you just prepare. It is what it is. It's stressful beyond belief, but you have no choice. I mean, you have to be ready, and ultimately they will be.
Yeah. Mark, some of the criticism of the defense in trial 1.0 was that the third-party culprit defense may have been too far for the jurors. And now during the hearing we just heard last week where they've named Colin Albert, Brian Albert, and Brian Higgins, does that now enter into your opening statement?
I see. To me, the third-party culprit is overemphasized by all on both sides. Obviously, the defense has to be some form of reasonable doubt, and clearly, the defense here has to be, I didn't hit him, meaning I literally did not cause his death because it wasn't a car accident. By definition, if she didn't do that, somebody else had to have caused his death because it's clearly not a natural death. He's covered in injuries on the back of his head, his face, and all over. So, I mean, by definition, there's some component of a third-party culprit in that if it wasn't her, it was someone else. And, do you need to dig in and name people and all of that? I mean, the risk is, do you tell the jury, even though you have no burden, are you shifting the burden, practically speaking? Are you potentially writing checks that you can't cash? Are you giving the jury the belief that, okay, they're going to tell me who did it, and they kind of screw up the burden of proof and what they're supposed to do? When you listen to some of the comments of the jurors, you start to wonder. So to me, it's always been wrapped around the science from the ARCA experts, first and foremost. I mean, literally no accident. So that's reasonable doubt right there. And to me, if there's no accident and the damage to the car could not have happened in that way, that is a perfect segue to the next critical point, which is, well, how the hell did all those taillight pieces get in the yard that the DA is so excited about? And it couldn't have been from a car accident, which we already established. Then that taillight, those taillight pieces couldn't have been naturally there. And if they were unnaturally put there, that means by a human being. And now you're segueing into, well, if that human being or beings can't be Karen, it gets to the cops. It gets to the strange behavior in the house. More importantly, it gets to the strange behavior on recovering taillight pieces over the course of 3 weeks. And then perhaps even more importantly, it gets to what can only be classified as the truly bizarre things that happen in the middle of the night, such as, the two Bryans have to have had the first butt dial conversation in the history of the planet. I mean, butt dials are hard enough, but I don't think anyone's ever heard of a literal butt dial conversation. You have Jennifer McCabe's apparently 10 butt dials, which is statistically, I would suggest, impossible. You have all those weird texts about the Asian house, and we'll tell you the next day, the visit to Lank's house, tell him the guy never went in the house. I mean, you could go on and on. But so to me, that's much more important than pointing a finger at Colin Albert, and I'm not saying you don't try to allude to it, but I don't know that that's really a point of emphasis, as opposed to, Higgins. He did have a motive, contrary to what Brennan said the other day. I mean, he obviously had a romantic interest and felt like he was being left out. Everybody knows what he did on the video in the bar where he looks like he's a tough guy pointing and come out. sends a text. I mean, I think all that you can weave in, but I would be very careful to oversell and risk assuming a burden that you don't have.
Yeah, and it's also interesting too. I'm sorry, Todd, and it's also very interesting too that listening to David Yannetti talk more in depth about the third party culprit the other day. He says he's got, he talked a lot about Brian Albert having a drinking problem, and when he's been around other officers, he's punched them before, and they're going to bring in this witness to testify to that. So I found that very interesting as well too.
Yeah, I mean, it's not the kind of thing. If you get it admissible, I wouldn't ignore it. I mean, I think it goes hand in hand with the reasonable doubt. But the ARCA, the planted taillight, and all the other things we discussed, I think are much more powerful to reasonable doubt than whether it was Brian, Colin, or the other Brian in some combination. I wouldn't ignore it, but I wouldn't emphasize it. And, at least in the first trial, there appeared to be a very strong emphasis on solving the crime when, from a defense standpoint, it's just reasonable doubt. And I mean, certainly in a summation, I would be using the words reasonable doubt every 5 seconds. And as you add each fact, I would be saying that in and of itself is reasonable doubt. Then you combine it with this, and it just becomes smothering. It's too much for the prosecution to get by. But when you start naming individuals and theorizing too much without concrete proof, you do run the risk.
Yeah, it's funny. The word we've been throwing around on this channel, and I'm sure you've all both heard this back in the grade school days, is KISS. Keep it simple, stupid. And not saying that anybody in this defense team is stupid, but you know what I mean.
Well, you have enough evidence to Mark's point. You have enough evidence to piggyback on each other to strengthen the case and to strengthen the reasonable doubt. Karen doesn't have to prove her innocence in our justice system. So to Mark's point, go with your strong suits, go with your strengths, and let that rule the day for you.
I also think another way to establish reasonable doubt is to discredit what the prosecution believes are their strongest witnesses and expose them as not reliable and not worthy of belief. And again, that doesn't necessarily having to translate to saying you're involved in a murder. And the obvious one here is like Jennifer McCabe. People can do this different ways, but I would methodically, on cross-examination, parse every single statement in chronological order that she gave to every single police officer. And if you study those statements, they're all different and they evolve. And she's going to tell you that guy got it wrong, that lady got it wrong, it's all wrong. And you'll see that when they start to evolve, and eventually only after they start getting accused of terrible things, whether they think it's fair or unfair, does it really cross the line into, I hit him, and over the top. That comes after they got publicly outed, not before. And that's kind of a big deal. But even her earlier statements, they're very inconsistent. They're not consistent with the other witnesses. They're not consistent with the first responders. And I really think that there ought to be a real, death by 1,000 cuts, slice and dice, methodical. It may not be as, flashy, I guess, in doing it because she's so combative and whatnot. But by the time you get to summation, it will be really effective. And then, you have, even before summation, every police officer who interviewed her will confirm whatever I wrote, that's what she said. And you were going to already, or whichever order it is, she's going to say, I don't care what they wrote, I didn't say that. And she will be exposed as, doesn't have to be a liar, although one could make that argument. The key is not reliable. She's not a reliable reporter. So all of a sudden that I hit him isn't so reliable. That stuff about the cracked taillight isn't so reliable. And if that stuff is not reliable on top of everything else, where are they going here? Yeah. The prosecution. I mean,
we tend to focus just on the first trial, but also keep in mind that prior to the trial were depositions. Those are also at play. That's testimony under oath.
Yeah.
that no one seems to remember anything, because it's especially Jennifer McCabe. She always has to be reminded of what she said or whatever. And I still love that spicy comment by Jackson in the first trial. And he goes, I don't know, you Googled it. And I thought that was just the moment. I was just like, oh, just Jackson laying down. Just so good. Let's see this here. Plot twist pending. Thank you for the 20. Says, I feel very concerned that there was a lawyer in the on the jury and wasn't selected as a foreperson. Auntie Bev just looked at PA's guy and chose him. Why not let the jury decide? The jurors claimed they were lost at times.
Well, I mean, I guess the first thought is it worked out okay for her. She's on the case as a lawyer now, so it's not all so bad. But my understanding is that, you know, they pick the juror the way they do it there. They pick it in advance, which I don't understand, because by doing that in advance, you're guaranteeing that juror is going to be one of the seated jurors, which makes everyone else less likely to be picked. You know, I would, you know, never accuse New York of being a sane state or anything, but, you know, the way they do it is, you know, you pick your jurors and then you have alternates, and you know in advance who the jurors are, who the alternates are. And juror number one, you know, you're sitting in the exit row, whether you want to do it or not, you're the foreperson. And that's the way it is. When you do it in the way that they do it in Massachusetts, and with all the other stuff going on in this case, it just leads people to get suspicious and doubt what's going on. And that's just a bad look, because the system can't function when everybody has no confidence in it. And, you know, a lot of things that happen in that county in particular, people doubt.
Yeah. I got a question here for Todd. Thank you, Auntie Bev's Kangaroo Court and Third Three Ring Circus. These names are just hilarious. $10 says, great show, guys. Here's a question for Todd. If Bev doesn't allow the FBI expert for the defense, can you testify on to what best practices should be and Ben for securing the scene and gathering evidence? And if you want to opine a little bit on that, Todd, you know, what wasn't done right would be really great. I know you talked a little bit earlier about it, but I'll leave that for you to answer.
Yeah, you know, former agent Easter is his name. You know, when the defense first introduced him at one of the more recent hearings, you could see Judge Cannoni pushing back against it. And then she went into the Bowden defense, and I'd asked Mark to kind of educate the viewers on the Bowden defense. But, you know, she's saying that there's no precedent in Massachusetts on that type of defense. I've testified in my use of force cases, but there's civil rights cases, so it's not a criminal trial. So it's kind of an apples to orange comparison, technically. But, you know, if there was an opportunity to testify, I would.
Good to know. Mark, do you want to opine on Bowden defense, just so if anybody's not clear on that?
Yeah, I mean, it's just a lawyer word for trying to establish reasonable doubt based upon an inadequate and or corrupt police investigation. And the reality is, any jurisdiction, you're going to be allowed to attack the integrity of the investigation and argue that it leads to reasonable doubt. And certainly in this particular case, there's more than a good faith basis to do it. You start with the obvious. The lead investigator was terminated for, amongst other things, exhibiting bias against the accused. So like that in and of itself would satisfy. You know, you have all these other weird things where they filled out paperwork properly. Everybody knows about solo cups and leaf blowers and Stop and Shop bags. But, you know, some of it is actually much more nuanced and much more important, like the failure to secure a crime scene. That's probably the biggest of all, because if they had showed up when they did, 6 o'clock in the morning, and if there was a cop there the whole time, and even if they switch, someone comes in over the course of 12 hours, we're not talking about an armed fortress. You could have like one guy literally sitting in a police car, just making sure nobody's screwing around. If they could establish that through however many witnesses that nobody touched the crime scene because we had eyes on it the whole time, and then you have the search guys come in and say, we found taillight pieces. Guess what? Can't be planted. Like, end of story. But they didn't do that. And so to have an experienced police officer, FBI agent, whatever, who has the right requisite experience come in and say, this is what you do, that seems fair. I mean, something Todd said earlier, same exact point. The car in Dighton, for all intents and purposes, that's the murder weapon. I mean, it's
That's
being a
just
little,
broken gun, right?
I mean, just being a little dramatic, but that's the vessel of death, according to them. And these knuckleheads go down there and they don't do a damn thing. And as Todd said, they should have called crime scene. They should have processed. I mean, Proctor said they're towing it. Here's an idea, idiot. Why don't you look at it, photograph it, and do all the analysis before you tow it?
Yeah.
Okay. Or, as I was joking when Todd was talking, take a picture of it. I mean, if they took a picture of the car and had the metadata to prove the date and time, and it looked like it should have looked like in the Sally Port 2 days later, again, where are you going with this? But they didn't do it. So you could go on and on. Another thing an expert might be able to say is, you know, my understanding is that the state police, and Todd's the expert on this, like any large police department, they have what I'll call colloquially, because I just go by NYPD, what they call the crime scene unit. They are the people who come out and process crime scenes. Okay. They do the searches and they document it themselves. They photograph. If appropriate, they dust for prints. If appropriate, they swab for DNA. They voucher. They do diagrams. They measure. Why did they not use their crime scene unit and use this CERT team, which is essentially a search and rescue type team, and who does not process the crime scene? In other words, they leave it to Tully and his goons, which fits right into the defense's hands. And you get a situation where the evidence is by the CERT team, as they're finding this evidence, oh, by the way, there were 5 unknown people, not from our team, creeping around the scene, helping us. Who the hell are they? Did they find the evidence? We don't know, because when the CERT team documented things, they did, or excuse me, Tully documented things. They didn't even document who recovered it at the exact time, who vouchered it, who did this. The crime scene unit would have done that. And that's really in and of itself suspicious, and they should be clobbered on that. And an expert ought to say, when you're looking for evidence, you get crime scene experts, not search and rescue looking for human life out in the woods.
That's just like, you know, Proctor was responsible for writing the search warrant. Well, that's not crime scene services role. They have a specific designated role. I can tell you my time in the fire marshal's office. If we went to a fire, we could say it was a single family home and we found a body inside, our investigation would cease, and then we would contact the local CPAC, whatever county we were in, and then they would indeed call crime scene services to document. Now, if it turned out that there, how was it again? If there was no smoke in the lungs, that meant that most likely there's a murder. There's some suspicious, this just becomes a suspicious death, because if someone was smoking, fell asleep, cigarette falls in between the cushions, lights a fire, they would have consumed smoke, inhaled smoke. So those are some of the things that we would look for from the medical examiner's report. That being said, if it was deemed where we found an unattended death, there was a body, automatic protocol is fire marshal's office steps out, CPAC steps in, they call crime scene services, and they document the scene. That's just the way it is. And then the other last point, Brian, on a crime scene, you slow things down. You don't rip through, because you're going to miss something. So I was always trained, slow things down. When the investigation's over, whenever it is, then it's over. But there's no, you're not on the clock. There's no pressure with TikTok, let's go, let's wrap it up. You slow it down and you be as thorough as possible.
Yeah. There's another really damning fact that I should add into this whole, you know, what the hell are they doing with the vehicle in Dighton? There was testimony in the first case from Proctor that based upon a couple of facts, one being that John O'Keefe was missing a shoe The other being that I spoke to Jen McCabe, and he never went to the crime scene or any, which is another expert type of testimony. That based upon those two facts, maybe a few others, he made a determination that this was a car accident. And he even said, on the way down to Dighton, we had already ordered the tow truck. That's a fact that really got glazed over, that is a lot more significant than you think. In other words, he's telling you, I already knew I'm seizing the vehicle without a warrant, as it were, which is a whole nother, I don't know how the hell that happened, but putting that aside, the point is, if he was so locked in that this was a car accident and we're going down there, let's not kid ourselves. We're not going down there to interview her. We're going down there to get her to incriminate herself and hopefully arrest her. We're going to take the car. We're going to take her phone. So you do go down there. You see the car. Wouldn't you want to confirm it's a car accident? You knew that Jen McCabe had told you what she told you. You claim, that there's going to be cracked taillight. Why wouldn't you simply walk up to the car, look around? By the way, there's no Fourth Amendment here. The car is in plain view. It's out in the open. You can dust the snow off. And if you're worried about doing that, you can video on your phone, dusting the snow off so you didn't tamper with anything. And then you take a picture, you take a video, you look at it, and there it is. And instead, these idiots at trial are introducing pictures from, 6 hours later that are foggy at the house in Canton at Meadows, arguing over whether that's white taillight or snow. And if Proctor wasn't such a moron, none of this would be an issue, because he would have had pictures the minute they got the car with metadata showing the whole taillight was cracked. So the bottom line is these cops on this case, it's amateur hour at the highest level, and an expert ought to be allowed to come in and say, here's how professionals work. And then they pass the baton to the lawyers to say, here's what it means. There's reasonable doubt. Because of
it's interesting, and I'm glad that you talked about the way of preserving the crime scene and attacking this evidence. I just watched it, and I've been talking about this a lot on Netflix. There was a new OJ series that dropped a couple of weeks ago, and they talked about the defense strategy and attacking the evidence. And I think that the Reed team has a real opportunity here. I don't think they did it, but I felt like they could have done it more to really get that over to the jury of how this evidence was, the evidence was collected. Again, to Mark's point, leaf blowers and shop, stop and shop bags and solo cups. And they talked about in this docuseries that what the defense literally did was they knew that there was news media down there. Obviously, we don't have that in this case. We just have photographs and some really crappy video of the leaf blowing snow around. But what they did is they looked over hours and hours and hours of footage that the media was shooting while they were collecting evidence. And they said, let's just go after that and expose it. They're not, picking evidence up in department issued containers. They're not wearing gloves. Evidence wasn't logged correctly. I think this is a real point. I've said this, that, possibly the Reed team could do this type of strategy and this as well too.
There's a lot of meat on the bones to be able to pursue that logic, Brian. And, you've heard me say this before, when you're in it as a fact finder, the innocent get more innocent and the guilty get more guilty. So even if you like someone for the crime, that if you follow the fact pattern, you're going to either crush that idea and move on to a different theory. And bottom line is you want to follow where the evidence is taking you.
Yeah. The leaf blower is interesting because everyone's first reaction when you hear about the leaf blower and you watch this, almost ridiculous video of an officer just blowing snow around. Forget all that. Watch the testimony again of, I think it's Gallagher, or if there's a transcript, watch him. And what he says is actually extraordinarily helpful and exculpatory to the defense. He says that I saw we went to an area where he was, they told us he was. And when we started doing this, we saw a ton of blood. Okay. And again, the blood is right where he was told the body was. So naturally, there is a logical assumption that's where John O'Keefe was. And so naturally, logically, that's where you'd think there would be evidence. And he says we start leaf blowing, but if you look at him really carefully, what he says is, I got all the way down to the ground.
Mm.
And I got down to the ground, and I think his testimony was in a 7-foot by 7-foot area where John O'Keefe was. Now, how in the hell
Would you know? Yeah.
down to the ground, and there's no glass, there's no taillight, nothing. How in the hell, when the CERT team, their area is going to overlap that, they find it? That makes no sense. If they got down to the grass and didn't see anything, and by then, in the early stages, the snow was still powdery and loose, but these guys found it underneath. The testimony from, I think his name is O'Hara, was it was like on the ground all the way. Yeah. And it was under the hard compacted snow, and we dumped it on the street, this and that, and they didn't find anything. But they did find it, and they found it within a matter of minutes.
Yeah, and then you have Paul that goes off of the CERT team and saying, well, this is where he was. He makes this diagram, and he even says, he testifies to it. He wasn't even down at the crime scene. He didn't even go there. And he's making diagrams, and he's going, well, this is where the CERT team told me that, he was, and I just kind of estimated. Like, what are you talking about? You're just estimating? I mean, come on.
He was, I mean, look.
I've worked with, I was never assigned to the CERT team, but I work with them as assisting the search for Molly Bish, and there was one other high profile murder where the CERT team was deployed back when I was active. They're experts at search and rescue. They are trained to look for fine, minute details. And I'm just going to stick with the tail lens discovery of all the pieces over that period of time. Why didn't the CERT team identify those pieces during their time on property? Now, you're talking about a front lawn. You're not talking about woods. You're not talking about trouncing through swamp area. None of that. A front lawn. Granted, it was snowing out, but it's a front lawn at the end of the day.
The answer is because they went home, because Tully said, we're good. They had 3 pieces. And then when the guy said, do you want us to come back in daylight? He said, no, we're good. Don't worry about it. And then they just waited until the snow melted, which again, unpreserved crime scene. What is the proof of this? You don't know if the homeowners were out there. I mean, you'd have to think they'd be curious, if nothing else. And they just let it come to them. I mean, this is the most asinine investigation of a high profile homicide of a brother officer in history. None of this makes any sense. And I would assume they'll get clobbered on this much harder the second time around than they were the first time.
Yeah, and then you look at the timing of towing Karen's car back to Canton, which is really weird. It should have went to a Mass State Police lab or Sallyport area. Should have been processed there and not driven 60 miles or whatever the mileage is. But then when it gets to Canton, it sits for 3 days before they start processing it. And it's like, okay, and going back to what Mark's saying, this is the smoking gun, this is the murder weapon. I mean, honestly, if I was on that team and I was directing that team and I was the lead in that, I'd literally be saying, we need to start processing this murder weapon right now. I mean, 3 days it sat there.
Well, again, you had Chief Berkowitz recuse them, right, from the investigation. So why wasn't there additional efforts to say don't tow it to Canton from the beginning? That was already stated before that vehicle was towed. Was it 3 days, I think, after they had already recused themselves from the investigation?
Yep.
Why take the chance and put the vehicle at Canton PD? It just doesn't make sense.
It doesn't make any sense. And the fact that they waited 48 to 72 hours to even photograph the vehicle is, I mean, who does that?
To your point, Mark, if everyone's thinking this was a motor vehicle accident, then minute 1, where's the vehicle?
That's the evidence. That's the murder weapon. Mm-hmm. I mean, the famous expression we used to use was, detective, go detect something. Why weren't they doing anything?
Not detecting.
Right.
Not detecting. Yeah. making stuff up, planning evidence. I want to back up real quick, and I'd love to get Mark's take on this. Thank you so much for the $5. Says, if Mr. Bederow, if Proctor does have an attorney in the courtroom when he's called to testify, what will that look like?
It looks terrible. I mean, let's call it what it is. I mean, it's not normal. I mean, look, I mean, I'm a defense attorney and tell people all the time, you shouldn't draw an inference from somebody consulting counsel and this and that. But when a guy's just a witness in a criminal case and he's getting clobbered about, you know, being fired and accused of planning evidence and all this stuff, and he's got a lawyer hovering over his shoulders, the optics of that are atrocious. I mean, there's no way around it. It looks terrible.
You think he goes up and pleads the fifth?
Well, if he's going to plead the fifth, which I said he should have done before the first trial, he could have notified the court in advance and he wouldn't have even had to go up there if he says, I'm going to take a blanket fifth. His problem this time is, I'm not sure he can. Okay, he testified to all these facts. He waived the fifth. So if he refuses to testify, he could be held in contempt. And presumably the defense would argue that we ought to be able to use the transcript from his first trial if he's, you know, refusing to do this. There is a very, very strong argument that that ship sailed, and that by speaking about these issues at the first trial under oath, subject to cross-examination, he waived it.
I'll never forget Judge Cannoni's words when Proctor was testifying. These are your words. You have to say them.
Mm-hmm.
Yeah. Yep. It's so great they did make him say him. Question for Todd. Being an accident trooper, what is the urgency to remove the taillight? Why is it evidence, and should it have not been touched? Oh, great question.
Great question. It shouldn't have been touched. It should have been documented as is. If they wanted to swap, and again, one of the lab analysts did some swabs looking for tissue in blood. That's all you need. That's what you're trying to determine. Was this vehicle part of the cause of this death? So there's no reason to disassemble the tail ends.
Yeah, I agree. Another question for Todd. Brian Albert has a side business for security consulting since 2020. Isn't that a conflict?
Not necessarily. It depends on the scope of work that he was hired for. The conflict of interest would come in is if he was utilizing department resources for his clients. The conflict of interest would be if he would interfere in any type of, I don't know, discovery of information in his office as a law enforcement professional could impede some investigation or information along those lines. But as a blanket side business, not necessarily. There's a lot of work out there that contractors can do.
So Dr. Russell's gasp, $20. I love these names. They're just great. It says, is it possible Proctor was fired for more than what he was dishonorably discharged for? Mass State Police doesn't want out there. That's another great question too.
I'm sure all those things were analyzed. I mean, I looked at the 4 found guilties in the charges that were, presented from the trial board hearing. I could name a couple additional extra that should have probably been in the lineup of departmental offenses, but there was enough there with those 4 to terminate him. So
we got Judge Kim Jong-no. Thank you for the $5. Is it normal to charge somebody with a homicide if the cause of death is not a homicide, like this in this case, undetermined? Mark?
So homicide is not a crime. Homicide is a factual, legal definition of one human being causing the death of another. But some homicides can be justifiable and not criminal. Self-defense. Somebody pulls a gun on you and you pull one first and shoot them first. That's killing them. That's committing a homicide, but that's a justifiable homicide. So, we're talking murder, manslaughter, that sort of thing, which are presumably not justifiable homicides. The problem here is, when the medical examiner says, I can't even tell you whether the manner of death was a homicide, that's a big deal. Yeah. And so, no, it's not, generally speaking, normal for prosecutors to indict someone for murder, which of course is not only a non-justifiable homicide, but an intentional killing by a specific, allegation that a car ran someone over and da 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 da. When the medical examiner is saying, well, hold on, I don't even know whether this is any form of homicide. And then later on is going to testify. I mean, it could be consistent with car accident, but not the usual kind I see. Could be consistent with getting beat up or getting beaten with a bat. There used to be in the Manhattan DA's office where I worked, and they would have these homicide meetings when they were going to charge people and whatnot. They would never even authorize an arrest until, basically the panel was satisfied that there's more than probable cause, even though that's the legal standard. We can prove this. We have absolutely positively determined that there's no alibi. We have absolutely positively determined that there's no justification. We have absolutely determined that the manner of death is a homicide and that this might not be an accident. And that's what most credible DA's offices would do. They wait, and you don't just arrest someone because, probable cause says you might be able to. These people in Norfolk County, in this case, I mean, they just snatched her up. Mm-hmm. And, that's part of the problem when they wanted to upgrade it to murder. That's why you saw all those text messages with Proctor and the other guys complaining about, the whack job medical examiner, another whack job, because she wouldn't give them what they needed or what they really wanted so they could upgrade it to murder. And that's just unprofessional investigation. I mean, they had their conclusion and then were working backwards to find, the testimony to support it rather than just following the evidence and going where it goes. And that's why certainly a guy like Proctor in this case and the people he worked with, they're just not professional. I mean, you just don't do it that way.
Yeah. All right, let's go there. The question's being asked. Question for Mark. How does the Docuseries affect trial number 2? And I'll leave that for Todd as well, too, what his thoughts are.
It ain't good. I mean, let's be honest. It's not good. It's kind of like an unforced error or an own goal. It's a free shot for the DA to attempt to establish a few facts that they may think help them. I don't think it's going to move the needle to the point where it's going to change the result, but there are statements in there. Having 6 drinks, that's not helpful. Making statements that, my memory is not as good when I've been drinking, but I don't think I hit him or whatever those words were. That's not good. Talking about a piece of glass pulling off his nose. I don't know that that's good or bad, but that's kind of like new. That's kind of not known. And I don't know what that means, to be honest with you, but I just, when you don't have the burden of proof, I'm not thrilled with the concept of like giving them ammunition to do these things. So they've created an issue that would not exist if she didn't speak in that manner. So how much does it affect? I don't know, but you have somebody who's like as hyper aggressive, like Brennan, who's like swinging from the chandelier with excitement to do anything and everything. The guy's willing to pierce privilege. He'll do anything. They're going to scour through that and try to find anything and everything and suggest it helps them. I don't know if it does at the end of the day, but it's kind of an unforced error for the defense. It is what it is. It's not good.
Yeah, Mark, you're spot on as always, but it creates an unnecessary distraction. And someone like Brennan, we're seeing his style as an attorney, and this is the type of things that he's waiting to pounce on, and to give him kind of a softball, if you will, for him to go and attack it. Maybe wait a little bit. get past this, slow things down, get past this. All the media attention will come in at the right time.
Yeah, the other way it doesn't help, and this is more just kind of a generalized thing as opposed to evidence. I mean, they can't control this, but it gets released, a couple of weeks before trial. And I mean, if you watch this thing and you're being honest to how it was presented, whether you agree with it or not, it doesn't portray her well at all. She doesn't sound good. And that could be editing. That could be any number of things. But the way it's cut and edited and presented, it's not a good look at all.
It's funny that you say that, Todd, about the timing of it, because interesting enough, I think like 2 or 3 weeks, maybe a little bit more time before that, we saw that series that Ted Daniel did with Karen. And I thought that the part 2 to it, the part when they're in the SUV together, was really the most humanizing thing about Karen. It was like she was talking about the case. She had a lot of information. She was very likable. And then it was like, oh, what's that, Mark?
Night and day difference. Yeah. But here's the problem. When you take a criminal defendant in an open case who says anything that can be used against them, and you agree again and again to do this, you're on a high rope, you're walking the wire without a net. And all it takes is one stupid or mistaken statement. And, sometimes you may do really well. Like, I agree with you. The Ted Daniel one was pretty good.
It's great.
But this other one on HBO was a unmitigated disaster.
It's unnecessary risk, and you've seen over the years when you have a defendant go on a PR campaign, because that's what it is, their attorney is shoulder to shoulder with them. So if you're going to do it, that's kind of the setup where it's safe. The attorney knows when to interject at the right time to protect his client. It is unnecessary risk.
Yeah, I knew it was going to be bad. I knew it was going to be bad when they kept featuring Plevin from Yellow Cottage Tales in there. I'm just like, oh no, this is not going to be good.
when you see, I mean, obviously him, and you see Coffindaffer, has no use as an analyst at all, more than any random person walking down Fifth Avenue would know as much or have as much value to this as she would. Obviously, that's not good. And the person who's talking on the defense side is the defendant, just constantly, again and again, and they're going after all the raw footage too that didn't even get published. And you'll have to wait and see whether that matters. But having said all that, I don't think it's literally a disaster in the sense of, well, that's it, the game's over, she's cooked. I don't think that at all. But it's just not helpful. But some of it isn't as relevant as you might think, even though it sounds bad. So when she says she had 6 drinks, that sounds terrible. But guess what? They have video of her with 6 or more drinks, from the bars. Now, all that does is wipe out any claim that it wasn't alcohol or whatever. And I don't know if that's what was going to be claimed or not anyway. But, it's basically a fact now that you had a lot of drinks. There's no way around that. And there's no reason to talk about that.
Yeah. Let me go to this one for Todd. Todd, what, if any, was probable cause to search 34 Fairview on 1/29 or days later? Would Higgins' text to John O'Keefe, "You coming," enough to do that?
Great question. And, in processing this and in thinking back to the morning discovery of John O'Keefe's body on the front lawn, in the first trial, I think it was Sergeant Lank that had mentioned, he was asked that by the defense, and he said, he defaulted right away. We didn't have a warrant. And so to search the house. So then I'm thinking, okay, what about exigent circumstances, right? If you can establish exigent circumstances, for example, tampering with evidence, or of something of that nature, you don't need a search warrant. Police officers are allowed to be able to search. So I think that would have been the best move, even if it was challenged at some point in the trial. Exigent circumstances would have been the best way to land on entering into the dwelling without a warrant.
Or I'm going to add this, or consent. You know,
Why
hey,
not ask?
you know why this guy's on the lawn? Oh, gee, officer, we don't know. I mean, just, you know, they knew at that time that they had been together earlier. He was coming over. Do you know how the glass ended up there? Whatever it is. Say, do you mind if we just kind of take a look around? And here's what's interesting. They would have every right to say no. But depending on how they react, they can escalate the cause, which could give a reasonable police officer who did not have cause to get a warrant based on their reaction. You can increase that. So if they say, hey, can we come in? And they're like, no, beat it. No, you can't go in the basement. Don't go in a police officer would reasonably say and follow up and say, well, why, what's in the basement? Again, it doesn't have to be confrontational. And the testimony of these guys is there's nothing to see here. So
you start at reasonable suspicion, right? We got a body on the front lawn. To Mark's point, yeah, you go for the consent. Depending on the reaction to the consent, that could escalate right to probable cause. Because
the other thing is, part of the questions that you would ask them, if they're doing this the right way, is, did you see anything? You know, do you have cameras? Do you know the neighbors? Do they have cameras? See how they react. They did nothing. They had no intellectual curiosity of anything. And then the guy who they ultimately assigned to the case claims he didn't even go to the crime scene for 3 days. I mean, to look where he was found, the flagpole, the fire hydrant, you would have seen the road is curved. You might have said, any number of things. He could have knocked on doors, looked for video. No intellectual curiosity. It makes no, but he was down seizing the car within a few hours. It doesn't make any sense.
Yeah. And I just always go on, like, any case outside, let's just put this outside of Karen Reed and all the ties to all the different people in this. Someone comes knocking on the door and says, there's a guy that's dead or practically dead on your front lawn. Do you know anything about it? I'm pretty sure normal people, if they just say, can we come in and just look around a little bit? Pretty sure normal people would say, yeah, because I don't want to be implicated in this. You know, do you know anything that's going on your front lawn? And to all of your points, it's like, yeah, come in. Yeah, I know I would be, because I wouldn't want to be involved in anything like that. And sure, you know, did you hear anything? Did you see anything? It's all basic normal questions in that scenario.
I mean, it was put online the other day. Somebody put up pictures. Next door neighbor saw everything, took pictures. They got up. They're farther away. They're farther away. This is 10 feet under Brian Albert's window. No dog barking, no one getting up. There's all kinds of suspicious stuff. I mean, if you had, because you have the cruiser video and you have the 911 call, you have Jennifer McCabe out there who is literally and figuratively cold as ice when this is happening in real time, where her friend is dying on the lawn. She is calm, cool, collected, has no reaction. When she calls 911, she has no affect at all, no sound of real concern, whatever. That's, people react differently. But her testimony and the testimony of her sister and brother-in-law is that she came running in like gangbusters, freaking out of her mind, screaming and yelling, crying, oh my God, oh my God. No, that can't be.
And Mark, who, and even Todd can answer, who lets potential suspects leave the scene and go inside a house? She left. Those officers allowed Jennifer McCabe to leave. And I don't know. How does that happen? I mean, I've watched enough cop shows where, I watch cops and there's a bunch of people at a scene and something might have happened in the house and there's people outside and they go, wait a minute, where are you going? Come over here.
No, in all fairness to her, I don't even know if in that literal moment they would say she was a suspect. However, to just meander into the house to talk to other people, most police officers would send a cop with her. Whether just because you don't know if the bad guys are in the house.
Yeah.
I mean, whether she's a suspect or not, the way they handled it was awful. I mean, it is what it is.
Todd,
And
clear
it's
it
all
up.
on video.
How do they allow this person to walk away?
Yeah, it just goes back to the sloppy part of the investigative response. I firmly believe that the initial response to 34 Fairview, they didn't know what they had. They didn't realize initially that it was a Boston police officer and who John O'Keefe was. And, was this a guy maybe that got hit by a snowplow, right? Just because of the weather, could have been a dozen different thoughts going on. But that goes back to my earlier point that once you make a decision to set up a crime scene, you slow everything down and you do things by the numbers.
I agree. Question about the jury on Tuesday. Can you go over how someone might be going for jury duty on Tuesday? Best answer the questionnaire honestly, but still be considered.
I'm not giving anyone advice.
Yeah, I wouldn't go over that.
You have a jury questionnaire, answer it truthfully and honestly. That's my advice.
Yeah. Mark, and thank you so much, BB2, for the $20. Says, Mark, can Bev legally stop a plane flying around with a banner message, i.e. ARCA, hired by the feds, or any other questions needed? So I guess because of this buffer zone now, this 200-foot buffer zone.
Practically speaking, no. I mean, she doesn't have authority to shoot down planes or, have her hand on the missile. No, I mean, in a literal sense, what can she do? I mean,
that's First Amendment, right?
I mean, well, she's got a buffer zone, but of course, this would be outside the buffer zone, right? The buffer zone is a couple hundred yards or whatever it is, not like a mile in the air. I would suspect, no, you can't. How do you stop that?
In a buffer zone, and does a buffer zone, to your point, Mark, does a buffer zone equate a no-fly zone?
Yeah, I was just going to say that if it's over a federal courthouse, they might just.
How do you even literally stop it? I mean, if somebody shows up screaming and yelling, holding a sign in a buffer zone, that's easy. One of the cops says, "Beat it, get out of here." But what are they going to do with somebody flying an airplane?
Yeah, I don't know. It's interesting. Very, very interesting. BB, $5. Maybe a dumb question. Can the jury be told to keep neutral faces so no one knows what they're thinking and they don't get kicked off?
No. I mean, they're human beings. They're allowed to react. And I mean, you don't want them to be inappropriate and say, you're lying and that's bullshit. I mean, that's not appropriate. But, you've heard of jurors. I mean, for example, the juror who's now on the legal team was said to have, shake their head vigorously at Proctor and gesticulated to the point where they clearly knew that's a good juror, right? That's human nature. Jurors are human. They hear things. And I think a lot of people, for example, when you hear these text messages that you don't know are coming out, how do you not react as a human being and say, my God, this guy's disgusting? I mean, it's just normal.
Lisa says, can the panel address the effect of lack of chain of custody as it applies to the evidence? We kind of went over a lot of that tonight. Glamasu says, question to Brian, Todd, and Mark. Are you buying Plevin's book, and will he autograph the first 5 copies? This guy already writing a book, putting it out there. Love the question. New Jersey Jen, thanks for becoming a new member. Let's see. Shelly, $5. Thank you. Says, would Karen's statement heard on dash cam that she left him there and he didn't come home be probable cause?
I mean, it could be a factor because that establishes his presence. And then you look at his condition, which is not a natural death. I mean, if you look at the statement, that could imply somebody wandered drunk and passed out and froze to death. The problem is when observed, I mean, John O'Keefe's body is in terrible shape. So, I mean, that's certainly a factor that could contribute. I don't know if that in and of itself would lead to probable cause, but that's certainly a relevant factor.
Let's see. Bev's raging hard on. Oh, God, $20. Great panel. Is there any punishment for the judge or Brennan being so biased and unethical?
I got nothing to say about either one of them, to be honest with you.
Yeah, let's see. Tsunami, thank you so much being a member for 14 months. A good friend of mine, a wrench, a moderator. Thank you, buddy. It says, question for the panel. Can federal law enforcement investigate be all completed but awaiting an indict and a charge at a later date? That's an interesting question.
I mean, I don't think they make announcements with the goal of or intent of misleading people and then pouncing months later. If they generate evidence that warrants an indictment months later, nothing stops them. I mean, the fact that they've apparently said we're not doing anything, that's not written in stone. They can do whatever they want if they have evidence at a later date. But, you know, federal prosecutors, they're governed by, you know, the U.S. Attorney, by the Justice Department. They have something called the U.S. Attorney's Manual, which basically dictates what they're supposed to do and lists all the guidelines and principles of their conduct. And federal prosecutors generally would not make a knowingly misleading public statement designed to trick people to snatch them up later. That's just not what they do.
I thought it was interesting yesterday when Hank made his comment about the federal investigation. He said, they investigated very thoroughly. I'm like, how would you know that? Like, what's your relationship with the federal investigation? I found that was interesting comment. Let's see. Michael, thanks for the 5. Says, crazy thought, Proctor, nothing else to lose, goes to the feds, gets immunity, and then ultimately sells the story for potential making millions. I don't think it's going to happen.
No, because he sent his family out there and say how innocent and honest he was. I mean, he's kind of boxed in publicly to being the innocent victim. So the idea that he's going to come forward and eat this and blow it up, I would say, is extremely minimal.
Salty Beach Girl Lori, thanks for the 5, says, didn't Bev basically make herself a face witness yesterday? She stated things as fact that are not in evidence anywhere. Is that even a thing?
I thought she did that several weeks ago when they were arguing about Fanning, actually. And I was actually in court that day because I had another case and presumably was going to be getting involved in that case. But I remember actually writing down a note saying, making herself a witness. Yeah, I mean, you know, when you purport to have direct knowledge of a material fact that's critical to the resolution of a motion, yeah, that, in my view, would make you a fact witness. I mean, you can't, just because you're a judge doesn't give you the right to, you know, not testify if you have a material fact that could be outcome determinative.
Bev's bias beratements, £5. Thanks for watching overseas tonight. Says, is there any chance this gang can be done on a RICO charge ever? All the conspiring law enforcement and civilians. Great panel tonight, Brian. Well, thank you for watching.
It's not likely. I mean, just based on the way things are, I mean, anything can happen, but I think we'd be foolish to think that's a strong likelihood.
Let's see. A desire for civil disclosure, $20. Said, pretty sure Chloe left during the night with Jennifer McCabe's daughter. Was probably with her in Colin. Investigation is too sloppy, and it was too sloppy too quickly, almost like they were experienced in the sloppiness. Yeah, I mean,
or
pretty
just
much
didn't know any better.
Yeah,
or just didn't know any better.
Pretty much. All right, let's do this. Let's get some final comments here. We're coming up at about an hour and a half, and I want to just both appreciate Mark and Todd for jumping up on the panel and doing this. How do you see this one shaping out? How do you think does the defense keep it simple this time around? Are they going to introduce, I don't know, new evidence that we don't know about? Is there going to be any mouth-dropping moments? I don't know. How does this all play out? Do we see a repeat in 1.0? I'm sure not. There'll probably be a lot of adjustments, but I'll take final comments. I'll start with Todd first and then go to Mark.
Yeah, a couple of thoughts there, Brian. You know, one, based on the witness list that the prosecution is going to bring forward, they've got to be able to counter that narrative. And despite thoughts around Brennan's style, he's good at what he does. and he has a very unique and savvy and clever way about his courtroom demeanor. So I think that the defense has a good working understanding now, based on these hearings, since he wasn't around in trial 1.0. So, I think part of their news strategy needs to be able to counter what these, the style of Brennan and the witnesses brought forth. Also, we talked earlier about the third party. To Mark's earlier point, in your point, Brian, keep it simple. They don't need that to find reasonable doubt on Karen's defense. So they have enough. Science is on their side. Again, I go back to the unsung hero from trial 1.0 is Lucky, the snowplow guy. He was very credible. He didn't blink twice when questions were asked. He spoke affirmatively. They need more of that type of testimony. And I also think that maybe a longer list of people to testify, not to complicate things, but just to shore up those loose ends. But I see an acquittal.
Mark, final thoughts?
I mean, I think the defense will be more vigorous, if that's the right word. In other words, I think that it'll be lengthier. I think they'll call more witnesses. I would expect that the cross-examination of the key witnesses maybe will be more methodical and maybe less sensational, in the sense that there's, as the word Todd used was, there's a lot of meat on the bone. And I think, not to be too critical, but the first time around, a lot of meat was left on the bone with a lot of these witnesses, just because. Now, part of the problem is, with all the sidebars and objections at the bench, she runs a really clunky courtroom. I mean, there's no flow, there's no cadence. And when you're cross-examining and you want to be effective, you need to have that flow and cadence, and you just don't have it in that courtroom. It's just an annoying thing that you have to deal with. But, they do have the advantage of seeing what everybody said the first time. I agree. It's good that they've had a long look at Brennan, because he's very different than Lally. I think he's obviously much more skilled, much more prepared, but he's much more sneaky too. I mean, he does seem fast and loose with the facts, and sneaking fastballs on the inside of the plate, and they have to be aware and alert for that kind of stuff. But I have no doubt that, given the opportunity to fine tune what's been done, that they'll do it well. And I agree with Todd. I mean, I just can't see any way that 12 people would ever agree that there's guilt on anything here. And I could totally see and expect that there would be 12 people who would agree that there's not guilt here.
It's funny. I was just going to ask you that question about Hank. I mean, is he that smart? I think he's just a cagey snake that throws a lot of shit against the wall to see what's going to stick in this case.
I mean, I wouldn't underestimate his intelligence or anything like that. He's a very experienced lawyer. He's good, but again, there are issues with his representations. I know. I've seen him say it about me, and he's full of shit. I mean, it's not true. I know for a fact what he was claiming to be true was in fact not true. And but when you say it in a courtroom, you can get away with that. You can't say it on the street, kind of thing. Yeah. So they just have to be alert, aware. The other thing that's very interesting too is a jury may not like him. That over aggressive sneakiness, it just kind of, it's there.
The theater he plays. It's like the theater he plays. Like and I'm sorry to cut you off, Mark. It's like, I wonder if he's going to do the whole, like what he was doing, like the book throwing, on the table, the shutting his folder like that and walking away. Do you think we see more of that during the trial?
Well, he's got to remember, you're the prosecuting you wear the white hat. You're not representing, a mafia killer. Okay.
Yeah.
It's not, this is not a bada beep, bada boop kind of trial. It's a little different. And when you're the prosecutor, you can't be bada beep, bada boop. You have to be the white hat. And again, though, don't confuse that criticism with a lack of skill. He can be very methodical, very smart, very experienced. And it's just some of these things that he's doing do appear sneaky. But, she's well represented. The lead lawyers here are very, very skilled trial lawyers, very likable in their courtroom presence. And, they're very, very good. And, I think they have the facts on their side, and they have no burden of proof. So they've got a lot to work with. And but I think we all, for the most part, expect that it will work out.
Yeah. I think it's going to be a very interesting round two. Very interesting. And I think there are going to be some moments like in trial one where there was like mouth dropping moments, Proctor's text, the conversations with Higgins, and then bringing his lawyer in. We're all like, what is going on?
There's going to be a lot of that. And to me, the one that will stick out is the inverted video, because this time they're going to be locked and loaded. We're not getting caught off guard. And, Buchanan's already locked in on all that nonsense. And to me, that will be the real, in terms of the advantage of the first trial to the second trial, how are they going to deal with that?
What was I going to say? One thing I love, too, is bringing Alessi to the forefront. I think he's a great matchup for Brennan. I love the back and forth when Alessi has his arguments, and I think he's going to match up well with Brennan. How do you feel about that, Mark?
Well, yeah, no, Bob's brilliant. Look at him. You watch what he's doing, and if you know him, you know that that's how he is. He's as smart an attorney as you'll ever see. And he's also wired in a way where he's really good with experts and wonky witnesses. Like, he's like a master at that. So I would expect him to be as good as it gets when it comes to some of that real technical stuff. Not every lawyer, is good at that. It's a kind of a different subsection of being a lawyer. He is a master at that kind of stuff, and certainly better than Brennan at it, as you've seen over the course of the last several weeks.
Yeah. He shows how methodical he is, in his responses. And again, very, very quick with articulate responses.
Mm-hmm.
Let's see, better with the Irish $5. Can you show pictures of dog bites? Show how much we've done that before in the past. I'm not going to hold these gentlemen up to do that tonight, but I do appreciate the super chat. I know there was a lot of super chats tonight. It was hard to kind of pick through and pick out questions. So I do apologize. I get to all of them. We have a lot of people watching tonight, and I don't want to keep them up too long. I usually like to just do an hour and a half here on the show, but I do apologize to the chat tonight. Just two quick ones before we end, and I let you guys go, and then I'm going to sum up here. And I'm not sure if Mark can answer this, but Vicky just sent $5 in Venmo and said, "Can Mark say anything about the motion that dropped today for Karen Reed and Turtle Boy? Apparently about probably the text messages or."
I have a lot to say about that, but unfortunately, this would not be wise to use as the forum for that.
Right.
There'll be hearings. It'll be dealt with, but I can't at the moment.
Yeah. And then another real quick one. Why were none of the prosecution experts subject to the same review as the defense experts?
When you find out, let us know. It doesn't make any sense.
Yeah. All right. I just want to, again, thank both these gentlemen for their time this evening. Again, we're less than a week away from jury selection and starting this trial. I think we all agree here on the panel that it is going to be a wild one, and there's going to definitely be some mouth-dropping moments. Todd, if you can just let everybody know where they can find you. I know you have a consulting business, and you just let everybody know here out there in the internet world here.
Yeah, thank you, Brian. LinkedIn's the best way to find me. Just Todd McGhee. And, if you're looking for any type of engagement, let me know. And if I can't provide services, I got a pretty good Rolodex. I can point you to someone who can help.
Yeah. And Mark, obviously we know you've Turtle Boy's attorney, and where can they find you? I know you're very active on X, and where else can they find your services if needed?
Just Bederow Law as my Twitter, X, whatever you call it, handle. If you Google me, you'll find all my, if you need services, as they say, I'm out there.
Perfect.
Preferably New York rather than Massachusetts. It's kind of tough to keep going back to Massachusetts.
Steak dinner for you and Brian when you come back on me.
Yes, let's do it.
Yeah.
Let's the three of us get together.
And it's recorded and documented, so.
I love it.
And that's a strong incentive to come back to Massachusetts.
And I'll tell you, Todd tricked me. We went out a couple of weeks ago, and a little restaurant that I didn't know was in my town, he brought me there, and I was like, okay, this is great food. So I thank you for that, Todd, because I didn't know that little gem was in our town. Todd and I live in the same town, which is crazy.
Well, you know, the little places that are, you know, sometimes unknown are the best. And if you guys ever make it to New York, I have the perfect off the path Italian spot, old school Italian. That's kind of our regular spot in the village. We'll take you there and we'll have a good time. They'll treat us well.
Let's do it. I'm up for it. Okay, I'm gonna let these guys go. Todd, thank you so much for joining. Mark, thank you so much for joining. We'll get you out just in time for the Celtics game if you're gonna watch that. And I appreciate your time. And maybe we come back and do this again during the trial when they start getting into the evidence, and we can kind of scrutinize that and go over it. But I thank you both for your time this evening.
Sure.
Thanks, Brian. Mark,
Have
good to see you.
Good to see you. Bye.
All right. Take care, guys. Okay. Okay. So I just want to thank everybody for being here this evening. Of course, I want to thank Mark and Todd again. I appreciate them coming over here and lending their expertise to this panel and this audience tonight. Such a fantastic live, and I appreciate all of the people that have come in and watched this. If you're new here, please make sure to like, share, and subscribe. Comment after this video. I would appreciate it. I appreciate all the financial support tonight on this stream. And what I'm going to do is I'm going to donate $100 to Karen Reed's Defense Fund. So I'll make that donation after the stream ends. I'll post up the receipt on my Facebook page, and I'll also put it in my YouTube community page. So we'll put the receipt up there, and I'll just put LTL chat raiser and put the date of 3/26/25. So we'll do that tonight. I just want to get to a couple of Vemos really quick. Tanya, thank you so much for the $25 free Karen Reed. Andrea, thank you so much for the $25. I appreciate that. And Barbara, thank you for the 10. We had a couple of cash apps come through as well. We had one cash app for $3 by Bethany, and I appreciate that. So we're going to we'll make a donation to Karen Reed's Defense Fund tonight. Again, I'll post that up so it's transparent, and you can just go right on her defense website and just look, and it will say LTL chat raiser. We'll put the date up there, and I appreciate it. All right, that's going to be it tonight. Thank you all so much for being here. And again, I appreciate Todd and Mark for coming up and doing this with me, and I look forward to possibly doing another one of these down the road. All right, everybody, I'm going to head out. I hope everybody has a great rest of the week, and we'll have some more lives here pretty soon. Appreciate you all being here. Again, make sure to like, share, and subscribe, and we'll talk soon. If I can get my outro here. Talk to everybody soon. Bye-bye.